channel for future reference. All right, so now it looks like we are getting ready to start the program, and I'd like to hand the mic off to our two partners, Keith Huffman and Tim Babcock.
Thank you, Catherine. So I'll go ahead and get things started here today. We are lawyers, so the first thing we have to do is disclaim everything and say, we're giving you advice, but you're not paying us, so you can't rely upon the advice. So what we're going to do is give you some general information today. Everybody's specific situation calls for quite a bit of change in our advice we give to people. So the littlest fact can actually change things dramatically as we plan for the future. So there's Tim and I. Tim more handsome than I am, but I've got a little weight on him, so we'll kind of go from there. So here's what the cost of care is. It used to be the greatest threat from assets going from one generation to the next generation was taxes. There are no more taxes at death for 99.9% of the people in America. Indiana's gotten rid of its inheritance tax. And for federal estate tax, you have to have more than $11.7 million per person before you have to worry about it. So most of our clients don't have to worry about federal estate tax, but they do have to worry about the nursing home. It's now $7,500 a month or $90,000 a year to be someplace you never wanted to be in the first place. And we advise lots of folks who are faced with long-term care costs. And there's a lot more of a safety net out there than people realize. And we're going to go through in some detail how all of that works here in Indiana. And what we're saying here is pretty specific to Indiana. There are different Medicaid rules in each state of the country. So as we're talking to families, we do a lot of estate planning. We'll talk about that more in our next week's program. But we have yet to draw up the first will that says, I leave everything to the state of Indiana, or I leave everything to the nursing home. So we kind of go from that as a starting point today. And there's a question about whether you should do planning for nursing home care or not. And the real question is somebody gets diagnosed with Alzheimer's or Parkinson's or dementia, is that 100% inheritance tax of a family? Or do they have planning options out there and available to people? So the cost of care, you can see what it is right now for a private room. And this is back in 2018. The average cost was about $8,500 a month. It's a little bit more than that around our area right now. So if you look at this thing, it's pretty amazing. But 2003 was the first time in Indiana since nursing homes were introduced that we actually had fewer people in nursing homes than we do today. So in 2003, there were 39,000 people in nursing homes in Indiana. In 2016, even though we had 500,000 more Hoosiers, we had fewer people in nursing homes. And that's the same trend that's happening nationwide. Indiana has been somewhat lax in doing planning for the alternative cost of care. The current administration is committed to doing that. And we're going to see a little bit more about Medicaid waivers and the commitment the state has to provide services outside of the nursing home going forward. So we're all getting older in the United States. There was an interesting thing in the paper today showing we have fewer people under 2 years old now than we do have for the people that are over 80. So as our workforce is getting older and older, the National Academy of Science, Engineering, and Medicine take a look at what are we going to do in the future in the United States. And they've recommended a national family caregiver strategy. And how do we support the families that are caring for loved ones at home? What kind of education we do? What kind of financial commitment do we have to doing that? How do we support the caregiver going forward? So one of their findings is that, and as you all know, hospital stays are getting shorter and shorter and shorter. They're doing more things on outpatient surgery, which means that people are going home with need for more care. And yet there's very, very little training or information that comes to these people. We have the CARE Act in Indiana that's supposed to alleviate that, but hospitals have been very, very slow to embrace that. There's been talk, most of the people that do caregiving at home are women. I know I have 3 sons, and my wife is worried to death about what's going to happen in the future. I always tell her I'm only going to unplug the curling iron, but we'll see how that goes in the future. But most caregivers are women, and the average caregiver that leaves the workforce to care for a loved one, MetLife estimated in 2018 they lose 303,000 of the economic benefit during their lifetime. And that economic benefit is money they would have for wages and Social Security. It can be considered what premiums they have to pay under Medicare when they leave the workforce earlier. And so the question is, how do we actually pay for those people? I know in one of Biden's provisions this year, there's $400 billion, a huge sum for caregiving. It's actually, some of it's needed. It's unlikely it'll pass in the infrastructure bill, but there's something that we're all talking about in the future of how do we pay for these things. Long-term care insurance. At one point in time, we thought this was the answer for everybody's problems. We advise clients all the time about whether they need long-term care insurance. And the whole marketplace about long-term care has changed dramatically in the last 2 or 3 years. The state of Indiana, just within the last week, has made severe changes to their partnership program. They actually have a bill that was passed and is going to be signed by the governor that will say we are actually changing our Indiana partnership policy and going to something that's more affordable if the federal government will approve a waiver for us. If it doesn't approve the waiver, the existing partnership plan will stay in place. But one of the problems with the partnership plan is it has a 5% inflation rider. Inflation's been a lot lower than that. So it's elevated the cost of care dramatically, and many people can't afford their policies. And as companies go forward and raise the premiums, many more people are dropping those policies. So as we go forward, you're going to have to consider what it is you're going to do with long-term care insurance. And we always talk to our clients about who should purchase long-term care insurance. We tell people the younger you are, the smaller the premium. But whether you buy it at age 45 or buy it at age 65, the total premium you pay during your lifetime is remarkably close to the same. We tell people the sweet spot is 59.5. If you have a group that you're a member of that you can take advantage of, that works out great. So if you're a member of AARP or you're a member of some other organization and they have a group rate, that can be very helpful. When you buy long-term care insurance, the premium should not exceed 10% of your income. We tell our clients that you're buying long-term care insurance to make sure that what you worked hard for all your life is going to go to your family and not to the state of Indiana and not to XYZ nursing home. So you're trying to save money and you want to make sure that you can afford that policy in the future when you don't have as much income coming in from retirement. We tell people you should have your home paid for and $250,000 in the bank. In Indiana, there are lots of ways you can qualify for Medicaid if you need long-term care. Tim's going to go through a lot of those details in just a few minutes. But if you're going to buy long-term care insurance, you want to make sure that you can afford it. And the last thing you want to do is you want to check the genetics in your family. If everybody in your family drops dead of a heart attack, you do not want to buy long-term care insurance. But if you have Alzheimer's or Parkinson's or dementia in your family, you seriously want to consider that. So here is the change that's happening in the long-term care insurance marketplace. Most of us, when we think of long-term care insurance, think of a policy that pays $100 a day or $200 a day for every day you're in the nursing home for a set period of time. There's usually a 90-day elimination period because Medicare often pays for the first 100 days. And then you have a policy that pays for some period of time. But within the marketplace, there are now a lot of hybrid policies. One of the problems with long-term care insurance has always been, if you don't use it, you lose it. And you buy insurance not because you want something bad to happen to you, but because you're betting that something bad will happen to you. And there's a reason the insurance companies have most of the money in the world. Actually, they're smarter than we are collectively, but not individually. So Lincoln has a MoneyGuard product now. So Nancy at age 65 is in good health. She buys this policy for $100,000. If she goes into the nursing home, there's an annuity rider that will pay about $6,900 a month for 6 years, up to $500,000. And she's going to pay a small premium for that each year. If she dies, the children get $156,000 death benefit, which is income and inheritance tax free. If she changes her mind, the original policy premium of $100,000 is there if you need it. There is, of course, a withdrawal charge, so she would actually get back about $70,000. So there are universal life policies like this with the long-term care benefit riders that are available for a number of different companies. And there are actually very few people who actually sell long-term care insurance in Indiana at the present time. This is another policy. This one is through the state life insurance company, where you can actually take money in an IRA and purchase a policy like this without having to pay the income tax now. But when you get the benefits later on, if you have it through a non-IRA account and you get paid that money, it's a reimbursement of an incurred medical expense, so it does not count as income. If you buy it within your IRA and it pays out benefits, that's income that's taxable to you. But again, it has a life insurance component, it has a withdrawal right. So the idea here is that somebody is going to get some benefit out of this policy at some point in time. And this is pretty amazing. In 2018, throughout the entire United States, only 350,000 people purchased long-term care insurance. And out of that 350,000 people, 84% bought hybrid linked policies, and only 16% bought traditional long-term care policies, which is a complete change in the marketplace from what we've seen before. If you want to read a very, very interesting book, Rick Edelman is a financial planner. His financial planning firm is rated among the top financial planning firms in the United States each year. He spent several years doing research, talking to scientists, talking to long-term care facilities, talking to Apple, Google, all the people. And he predicts in his book called The Truth About Your Future that nursing homes will not exist after the middle 2030s. He says the technology changes in medicine and science are going to be so staggering. And he says we're all going to have 5 or 6 individual robots. So he says there won't be nursing homes. Now, I'm not sure if that's the case or not, but it's certainly very interesting to consider what may be the alternatives. Japan is actually an older culture than the United States, and they are actually working on robots that get people out of bed, go to the bathroom, and bring them back to bed. And if you go to a long-term care facility in Japan right now, you're going to see a robot in that facility. And most of the robots right now are either taking food to residents, or they're actually playing music for the residents and doing their entertainment as the entertainment director. So the technology is changing very quickly as we go through this. And this is part of the Indiana Plan to Age in place. The Indiana Division of Aging is committed to providing more services to more people at home so they don't have to go to nursing homes. AARP does a study every year about where states spend their money as opposed to, do they spend it on long-term care facilities or do they spend it on care at home? And traditionally, Indiana spent about 56% of its dollars on long-term care facilities and the balance on people at home. And the state of Indiana is committed to changing that. So the idea here is you can see each one of those years, they're going to add 2,000 or 3,000 waiver slots. And what this is for people who need long-term care, but they could be at home because there's enough support structure for loved ones, or they can be at home because they're not quite as bad as they might have to be permanently in the nursing home. Then if Indiana can actually do this and they can provide services, if Indiana is providing services to somebody in the nursing home, it costs the state about $4,800 each month. If they can provide services at home, it costs the state about $2,600 each month. So if we can actually spend the same amount of money, we can save $560 million a year providing services to people at home instead of in a facility. And all of our clients would much rather receive services at home instead of in a facility. There is also what's known as the Age and Disabled Waiver. And these are people who can live in the community setting. They are approved for level of care, by the local Division of Aging. In our area, Aging and Home Services is the gatekeeper for the waiver program. They do an assessment to make sure what activities of daily living you can do on your own. And if you can't do those hours, then you get a service plan that shows what hours you're going to get. And the average person gets somewhere between 20 and 35 hours of care each week at home, so they can stay at home so they don't have to go into the nursing home. We have Laura Jennis and her home court people here in Bluffton that are doing all kinds of services for people, and we work very closely with them to help people get services at home as soon as possible once they get approved for the waiver. These services are not typical nursing home services. They're more like housekeeping, feeding, assistance, respite care, can be companion care, and that type of thing. So Medicaid waiver program provides services who meet the financial criteria for Medicaid eligibility, which Tim's going to go through in a few minutes, and they meet nursing home level of care. We have an income cap in Indiana. You may have heard of the Miller Trust or the Qualified Income Trust. So a little story, Lottie Ham was a resident of Colorado, and she had severe Parkinson's disease and went into the nursing home and was there for 4 years, and her husband died. And when he died, she went to his level of Social Security, got half of his small pension, and all of a sudden she was $20 over the income cap in Colorado and could no longer qualify for Medicaid. So her daughter, Jeanette Miller, which is where we get the Miller Trust, paid for her care for a year and a half, about $40,000, and she ran out of money. And she sued in federal court and said, "Judge, this is not fair." And the judge agreed with her. He said, if you'll set up an irrevocable trust and you'll put the excess income into that trust each month, that money then goes to help pay for Lottie's care. And if there's any money left over when she dies, it goes to repay the state. If you do all that, we're not going to count the extra $20 of income she gets, and she can qualify for Medicaid. And the next year, Congress made that a national law. We didn't have that law in Indiana until 2014 because of a new law that went into effect. You may have heard of it, Obamacare, the Affordable Care Act. So we started having qualified income trusts that year. This year, if you are the Medicaid recipient and your income is above $2382, you need a qualified income trust. The excess income goes into that trust and then goes to help pay for your care. We do have a lot of people that are in assisted living in our area, and we are blessed. We have a lot of excellent facilities. Heritage Point has participated in that program for a number of years. So has River Terrace, Christian Care, and the last one to join the party is Woodcrest. They now have the assisted living waiver program at that point in time. All the spousal impoverishment rules apply to that. Tim's going to go through with you. The person pays a room and board cost of about $794 for a studio. If they want to get a little bit bigger room, they can pay a little bit more. And then the state pays the facility one of 3 different rates based upon level of care. And that level of care is based upon how well the person can get along and whether they can get down to the cafeteria by themselves or not, and things like that. And with that, I'm going to turn it over to Tim.
Great. Thank you, Keith. So felt a little bit like my son, who is a track athlete, passing the baton back and forth here. So Catherine did the handoff to me here, so I'll run things for a little while and then hand it back to Keith when we're all done. Just as a friendly reminder, if you do have questions about anything that we've talked about, go ahead and submit those via the chat feature, and our staff will collect those, and then we'll go ahead and try to answer those when we've got all the presentation all wrapped up here. For the benefit of those who maybe joined the presentation a little bit late, I do want to hit on something real quickly, and that's the fact that a lot of people view Medicaid as health insurance for the poor. But the reality is that Medicaid is going to cover the cost of care for the majority of individuals that are over the age of 65. Keith had done a slide earlier that shows the average cost of care that someone's going to pay in a nursing home on a monthly basis. And that cost is going to easily exceed over $80,000 a year. So while Medicaid can provide a nice safety net for folks that are in the nursing home, we have clients that come in to see us all the time that want to leave a legacy to their family, and that's where a good Medicaid plan is going to come into play. And so we'll go ahead then and dive into kind of the mechanics of what Medicaid looks like. So when we're talking about Medicaid eligibility, There are some assets that count and some assets that don't count. This particular slide depicts assets that do not count. So we got prepaid funeral arrangements. Those do not count as an asset. We've also got down income producing property. So the thought there is if you own a piece of property, it's producing income, that's less money that the state of Indiana has to use for the cost of your care. Medicaid is going to allow you to hang on to that particular asset. The drawback to that, of course, is going to be when you pass away, Medicaid does have the right to recover against that particular asset. But again, it's possible for you to be in the nursing home owning the 80-acre farm and still qualify for Medicaid. One vehicle of any value does not count for Medicaid eligibility purposes, and the home does not count if certain persons are in the home. So if you have a spouse that's living in the home, if you have a minor child in the home, if you have a disabled child who's in the home, or if you, and this is particularly important in the context of a single individual, if you are offering the house for sale or rent, it does not count as an asset. And speaking of single individuals, I want to draw a distinction real quickly here between Medicaid rules for a single individual and for a married couple. Because even though we're talking about the same program, Medicaid, seems like the rules should be the same. They're actually very different depending on who it is we're looking to qualify. And so let's go ahead and talk a little bit more then about a single individual. So anytime we're talking about Medicaid eligibility, there are two things that we're going to look at. We're going to look at the person's assets and we're going to look at the person's income. And so with the exception of the slide that was previously up there showing the assets that do not count for Medicaid purposes, for a single individual, just about everything else is going to count. And this is a relatively easy test. You cannot qualify for Medicaid if you have resources that are more than $2,000. If we shift our focus then to income, the basic premise is whatever income the applicant has coming in, that's going to go towards the cost of their care. Now we're going to allow a $52 personal needs allowance to be taken off of that amount. We're also going to allow you to deduct the cost of supplemental health insurance. And then finally, we're going to allow you to deduct the excess of the Medicare Part D premium over the Indiana benchmark. So let's run through a quick example, I think, which helps flesh this out. So we've got an individual with $1,000 of income. They've got a $250 pension. That means they have total income of $1,250. We're going to subtract off a $52 personal needs allowance. We're going to subtract off $150 for their supplemental health insurance. That then leaves a total of $1,048, and that is what that individual is going to pay to the nursing home each month to cover the cost of their care. So let's go ahead and then run through an example of what we might see for somebody coming into our office. So in this particular example, mom has a $10,000 IRA. She's got a savings account of $40,000. She's got a home that's valued at $60,000, and she's got a car that's valued at $10,000. The home does not count if she agrees to offer it for sale or rent. The car doesn't count because, again, one vehicle of any value is exempt. So mom takes that $50,000 from the IRA and the savings account. She gives it to her son. Now, the gift of that $50,000 is going to create a penalty. And we'll talk then about the impact of what that looks like. So we take the $50,000 gift, we subtract off $1,200, which is the de minimis amount that she can give away without causing any sort of penalty or eligibility issues. So that means that mom has made a gift for Medicaid purposes of $48,800. We divide that by $6,681, which is the magic number that the state of Indiana says it costs to pay for somebody in the nursing home for 1 month. That comes out to 7.09 months. Running through the arithmetic gymnastics there, that 0.09 months transfers into 3 days. So as a result of the $50,000 gift, mom is now going to be ineligible for Medicaid for 7 months and 3 days. How are we going to pay for the cost of her care? Well, in this particular situation, Son is actually going to use some of the money that mom gifted and loan it back to mom, which is going to help cover the cost of her care during that ineligibility period. We're going to cover that loan that mom has made, or that son has made, with a promissory note on the house, so that when the house sells, that loan is ultimately repaid. So just as I say, a pretty typical example of what we work with on a regular basis. So let's shift our focus then to—
Jim, if I might just
Yes,
interject.
sure.
One of the things that we've done at that point in time is we've actually gone down and filed a Medicaid application for mom. So we've disclosed everything that we've done and just said here in our Medicaid application. The Medicaid office has calculated everything and came up with the same formula that we did.
Sure, absolutely, that's right. And everything that we're doing, all the advice that we're giving is all above board. If the Medicaid caseworker was sitting in the room with us right now, we would disclose everything that we're doing. We're not hiding anything. We're not cheating anybody. We're just following the rules the way that they're ultimately written. So let's shift our focus then to a married couple, and you'll see those initials up there, the MCCA, and that stands for the Medicaid Catastrophic Coverage Act. And this is a very important law that passed in the late 1980s. Prior to this law, you might have heard about horrible situations of judges having to go into nursing homes and filing divorces for individuals having to declare bankruptcy. And the reason for that is, under the previous rules, a married couple could only have $3,000 in assets and qualify for Medicaid. So thankfully for our married couples, we had the passage of this very important law. And this law sets forth some important definitions. So we've got the institutionalized spouse. That's the one that's in the nursing home or the one who's receiving waivered services. We've got our community spouse. That's the one who's living at home or in an apartment or even living in an assisted living facility. We've got a snapshot date, which I'm going to talk about in the next slide, why that's important and what that means. And again, we've got different rules regarding assets and incomes. So let's shift our focus then to our snapshot date. So if we have a married couple and one of the individuals goes into a hospital and they're subsequently discharged to a nursing home without any sort of interruption by going home or anything along those lines, then that date becomes that individual's snapshot date. What Medicaid is going to do, they are going to take a picture of the assets that the married couple owns as of that date. And with certain exceptions that we'll run through in a subsequent slide, it doesn't make a difference if the assets are his, hers, or combined. Medicaid is looking at everything. But again, this date becomes a snapshot date, Medicaid taking a picture of the assets, and the Medicaid rules then say, okay, once the couple's assets is less than half what they were on the snapshot date, that individual that's in the nursing home is going to qualify for Medicaid. And there's a minimum and there's a maximum amount that's going to apply in this particular situation, but that's the general rule as far as eligibility for a married couple goes. And keep in mind that mom and dad are always going to have different snapshot dates. So let's run through another typical example of what we might see coming into our house. So let's suppose that mom is hospitalized, she has a fall or something along those lines, she's in the hospital for a period of time, and then subsequently is discharged to a nursing home, and it doesn't look like mom is going to be able to return. And so the first date that she went into the nursing home is going to be July 15th of 2020. That date, it then becomes her snapshot date. So on that date, dad owns a $100,000 IRA. Mom's got a $20,000 IRA. They own a $60,000 savings account. They own a house, which is exempt, and they own a car, which is exempt. So as we're going through the assets to determine the value of the snapshot date, there's a couple things to keep in mind. So one of which is the fact that mom's IRA counts, but under present law, dad's $100,000 IRA does not count. And you want to keep this concept in mind because prior to COVID, there were some rumblings that Medicaid was going to start to count the IRA or the retirement accounts of the community spouse. And again, as I say, the whole COVID fiasco sort of set into motion, and they tabled that for the time being. But that is something that could creep up at some point in the future. So you want to keep that in mind. So we got mom's $20,000 IRA. We've got the couple's savings account of $60,000. That means we've got a snapshot value of $80,000. Mom is going to then qualify for Medicaid when the couple's resources are less than $40,000. Well, how do we reduce down that $40,000? We've got a variety of options. So dad could go ahead. He could cover funeral expenses for both mom and dad. Again, prepaid funeral arrangements do not count as an asset. Dad could trade in his existing car. He could go out and get a newer car. Again, one vehicle of any value does not count. Dad could also pay attorney's fees, which is obviously our favorite part of the equation, but using a combination of any of those methods, as long as they can get down below $40,000 in countable assets, as of the end of July, mom is then going to be eligible for Medicaid as of August 1st, okay? So let's talk then about the income rules for a married couple. So the same overall concept is going to apply here with the income of the institutionalized spouse going to cover the cost of their care in a facility, with one important distinguishment, and that's the fact that the spouse that's at home is entitled to a minimum amount of income of $2,155. If they do not have enough income on their own to reach that level, they are then entitled to an allocation of income from the institutionalized spouse. And as the slide shows, that income allocation is going to be increased if there are what are deemed to be excess shelter expenses. And those could be in the form of mortgage, if there is rent, if the individual is in independent living, assisted living, if there's real estate taxes that are being paid, homeowners insurance, utility, any combination of those can help to increase the allocation over to the community spouse in this example. And the name on the check rule, as the slide shows there, that just depicts the fact that the name on the check is going to determine where the income is ultimately allocated. So again, this is best, I think, illustrated through an example here on this particular slide. So mom has Social Security of $1,800. She also has retirement of $700, giving her total monthly income of $2,500. Husband in this situation only has Social Security of $400, which means he's short of that $2,155 income requirement. So that means we're going to take $1,755 of mom's income and move it over to dad to get him up to that $2,155. So we subtract that off from mom's $2,500. We're at $745. Again, we're going to subtract off that $52 personal needs allowance. We're going to subtract off $130 for supplemental insurance, leaving us at $563. So that is the amount that married couple will pay to the nursing home on a monthly basis. Okay? So let's then talk about the house. What kind of options do we have for the house going forward? Well, if a child has moved into a residence with mom and they have provided care for mom for more than 2 years, which we want to document, which that care has helped to keep mom out of the nursing home, mom is then able to transfer the house without penalty to the caregiver child. And it's also important to note that that not only applies to the resident, but it also applies to any sort of contiguous real estate. So if you've got a house sitting in the middle of the 40 acres that's been in the family for generations, that land can also be transferred in conjunction with the house. So if you sort of anticipate on the horizon, you've got a similar situation to this, that mom may need care at some point in the future, and you've got a child who has the ability to sort of uproot their life, there may be some degree of benefit to them in the form of being able to transfer the real estate without penalty, okay? So mom, in addition to transferring the house to a caregiver child, they can also give the house without penalty to a spouse. They can give it to a minor child, they can give it to a blind or disabled child, and they can also transfer the house to a trust for the benefit of a disabled child. And the advantage there is this trust does not carry any sort of a payback provision. So in addition to being able to transfer the house prior to a transfer, mom can actually go in and make improvements to the house while the child is living there to make it overall a better residence. And those improvements don't cause any sort of additional penalty when the house is ultimately transferred. If we're speaking in the context of a child providing services for mom, we always want to make sure that we are using what's called a personal services agreement. And so that is going to dictate the terms of the care that a child is going to provide. We're going to have taxes withheld. We're going to have unemployment. We're going to do workman's comp, all of those things. And those are very important to have in place because anytime you apply for Medicaid, your financial life becomes an open book. Medicaid always has the ability to look at your check register, to look at your bank account statements to see what checks have you written. And if they're seeing a series of checks written to an individual for mom's care, but that's not being done pursuant to a personal service agreement, Medicaid is going to take the position that those services were gratuitous and all those transfers for care were actually a gift, which is going to cause us an issue. The slide also notes the need to use a transfer on death deed. And this is especially important in the context of a single individual. Anytime that someone has been on Medicaid, Medicaid always has the right to recover when they've passed away against assets that individual would have owned in their own name. So if nothing is done with the house, mom passes away and has been on Medicaid, if the children want to sell the house, they would have to open up an estate. And as a part of the estate process, under the terms of a law that was recently passed, you're now obligated to provide notice to Medicaid if you open up an estate. And so if you do that and the individual has been on Medicaid for any period of time, Medicaid is going to come running in right away and they're going to file a claim. But if you do a transfer on death deed or even a basic trust, you're flipping the tables. So now if Medicaid wants to recover against the property, they have to come into the county of residence, they have to open up an estate, and then they have to make a demand on that property that passed via the transfer on death deed. And we're seeing mixed results on that. It seems to be all across the state. In some areas, Medicaid is doing estate recovery. In other areas, they're not. And even if they do estate recovery, we do have sometimes the ability to negotiate on the amount of transfer that ultimately, the amount of penalty or claim that ultimately does have to be repaid. So a couple more slides for me to wrap up, and then I'm going to transfer back over to Keith. And these are kind of teasers. These are going to be covered in length in future presentations that we're going to do. And so the first one talks about protecting the family farm. Being here in the Midwest, we have a lot of farming clients that are always concerned with what can they do to make sure the farm that's been in the family for multiple generations is ultimately protected. And so what we ultimately advocate for a lot of our farming clients is what we call the Medicaid LLC. And so what this LLC does is it allows mom and dad to continue to maintain control over their farm, but also ensuring protection from future creditors, including Medicaid estate recovery. What does this process look like? Well, we have the children come in and they're actually going to form the LLC. Mom and dad are going to deed the farm to the LLC, but they're going to hang on to a life estate for the duration of their life. What this means then is mom and dad still get all of the income from the property. They still have to pay all the expenses, but they really don't notice any sort of a difference for the duration of their lifetime as far as the ownership of the farm. That transfer of the remainder interest is going to go ahead and trigger a 5-year transfer penalty. So we know that they're not going to be able to qualify for Medicaid for at least 5 years. So we want to make sure that we can keep them out of the nursing home, or that we do this early enough to where nursing home is not going to be really an issue for them. So if we can get through that 5 years, we know that the farm is going to be protected against Medicaid estate recovery, because under current law, there is no recovery against life estates. And most importantly, because we had mom and dad hang on to that life estate interest, the farm is included in their estate for federal estate tax purposes. that means we get a step up in basis for the farm to fair market value as of the date of death of the survivor of mom and dad. So really important benefit there. Again, as the slide shows, Michael Huffman here from our office is going to be discussing this topic on May 25th. And to wrap up for myself, we'll talk about real quickly about special needs trusts. So the context of special needs trust that we're talking about here are what's known as a first party special needs trust. So these are trusts that you would create for an individual who's receiving government benefits that allows them to receive a sum of money but still maintain their eligibility for those benefits. And typically this is going to come in the source of an inheritance that they might receive, or even a settlement if they've been injured at some point in their lifetime. As long as the trust is being used solely for their benefit, then the assets of the trust do not count as an asset for Medicaid purposes. And what we like to recommend in these situations are what we call a tandem trust arrangement. And so what that looks like is we've got our special needs trust, but then we have the trustee of the special needs trust go ahead and create an account with a pooled income trust company, like the ARC of Indiana down in Indianapolis. And so the ARC of Indiana is very familiar with special needs trusts, the rules of Social Security and Medicaid. They know how to make distributions for the benefit of an individual without causing any sort of disruption in that individual's benefits. And so what we ultimately do is essentially have the trustee take and replenish the ARC trust on a regular basis, and then the ARC takes care of making distributions to or for the disabled individual. They take care of the reporting requirements, and that's an arrangement that works very well. Of course, there's trade-offs with anything. The fact that Medicaid allows you to have this type of trust without causing a disruption in benefits means that when the individual who's the subject of the trust passes away, there is going to be a payback provision. And the best means to avoid having to have a first party special needs trust is really through proper planning to create a third party trust before an individual passes away, so that there is no Medicaid estate, or there's no recovery when our individual passes away. But that's a topic that Kristen and Sam Ladowski are going to cover in our series on May 11th. And with that, I'll turn things over to Keith to wrap up. He actually has some really exciting breaking news that came out last week, and he's been very instrumental in this process. So I'm sure he is very enthusiastic to tell you all about it.
Thanks, Tim. One important point that you made, though, is the personal needs allowance. That's how much somebody gets to keep each month if they're in the nursing home. So if a single person is in the nursing home on Medicaid, they can only have up to $2,000 in their bank account, and they only get to keep $52 each month. And that's got to pay for their clothes, their hair care, whatever else. That actually used to be $50, and they moved it all the way up to $52. And I actually have a client in Swiss Village who was so excited about that news, he told me that he would buy me a beer if they ever sold beer there. And I am ready to collect at any point in time. So this is very exciting news. PACE is what's called a Program for All-Inclusive Care for the Elderly. So I'm chairman of the Board of Aging and Home Services, which is our local area agency on aging in northeastern Indiana. And we have been working for the last 2.5 years to get a PACE program in Fort Wayne. And last week we got the official approval for CMS, so we can now start enrolling patients. It's an awesome, awesome program. So this is called a Program for All-Inclusive Care for the Elderly. And the idea here is that these are people over age 55. They need nursing home level of care, but they can live in the community. And most of them are going to be considered dual eligibles, Medicare and Medicare. Now, some of them will be under spend downs. So instead of being under Medicaid, they'll be spending the equivalent of what Medicaid would pay us each month for their cost of being there. And the average person that's going to be in the program on Medicaid or Medicare is not going to have a liability for this particular program. So our headquarters, as you pictured here, has been out at Lake Avenue for years. And we have completely moved our staff to the old Physician Health Plan building across from Lutheran Hospital. And we have retrofitted this building, and it's a gorgeous building. You can't see it, but in the back, there's woods back there, and it's entirely glass that overlooks the woods back there. We have within our facility, it's a medical center / community center. And the idea here is that we bring these people into our facility 2 or 3 times each week, so they get a lot more social interaction, and we get to observe them medically. Can you imagine a healthcare system where we make more money based upon how healthy these people are instead of how many procedures we do to them? And we also become responsible for their transportation costs to and from healthcare. So we have drivers that go pick these people up. We bring them into our facility. We get to observe them medically. We have physicians. We have 26 different specialties we've contracted with so that we have all the services that we need. We have a hospice. We have a nursing home. We have assisted living. So as people age out, they're still going to be in our program. We're still responsible for their care. And what kind of services do we provide to them? Primary care. If they go to the hospital, it's on us. And the idea here is to educate all the emergency rooms in the area to try and keep our patients out of the emergency room. Average person over age 85 goes to the emergency room, they're going to be admitted to the hospital. Once they're admitted to the hospital, they're going to be in a bed. Once they're in a bed, they lose 1% of their lower muscle mass every day they're in that bed, and all of a sudden they're not walking. So we want to work with all the emergency departments in our area to keep those people out of the emergency. Nationwide, the average person in the PACE program is in the emergency room once during the year, as opposed to the age group, which is a lot more than that. We provide their medications so they don't have to worry about taking one pill or not taking a pill. And one of the nice things about doing this is that we have flexibility. A lot of the Medicare and Medicaid programs they're fixed in. You can only have so many treatments as far as physical therapy. You can only have so many of this or so many days of this. We're flexible. We get these payments. We can do whatever we think in the judgment of our physician is going to improve these people's lives. It could be handicap modifications to the home. It could be a ramp. It could be a lot of different things. So this is a kind of a PACE participants nationwide. So 46% of the patients that are going to be enrolled in patients nationwide have some type of dementia. And they average 5.8 chronic conditions. So it could be vascular disease, it could be congestive heart failure. These are people that actually need lots of care, but we can provide that care for them in a less restrictive setting. So what happens with PACE participants nationwide? 70% are women, 30% are men. Now, this is significant because if you go to the nursing home, 85% of the women in the people in the nursing homes are women. So what this does is allows men to stay in the community longer and receive services. The average age of a person in the PACE program is 76 years of age, although 15% are between 55 and 64. And they shows then the average person in the PACE program needs help with at least 2 activities of daily living, and that shows up on that chart there. And we wanted to leave some room for questions and answers at the end. Our elder law webinar seminar, let me just give you a few tickler things. All of our healthcare consent laws in Indiana are going to drastically change as of July 1st of this year. Senate Bill 204 made tons of changes in those bills. That's going to be phased in over a 1.5 year period. We'll be talking about those changes. There are also changes in how you sign wills and how you sign powers of attorney in the future, and we'll be talking about those things as well. So going forward, we're going to stop our presentation.
Oh, we do have a question. So someone has posted, any thoughts on purchasing SPIA Medicaid compliant annuity to reduce countable resources for the married couple?
Yes, we do that. What happens in this situation, and we do this particularly when there's not children involved anymore. So mom has $300,000 in the bank. Dad goes into the nursing home. Mom takes her $300,000 and she buys an annuity. She annuitizes it over a 5-year period. So she's getting a monthly payment each month of about $6,000. that becomes income to her, and that makes dad eligible for Medicaid the first day of the next month. So you can use annuities in doing something like that. That can be a very, very valuable experience, and we use annuities like that quite a bit.
The one thing I'll say about that too, though, is, and maybe a reason we've started to move away somewhat from annuities, is we have a tendency to utilize more of family loans. And the advantages to those are those can often be set up for a much shorter period of time. Anytime we're using Medicaid annuities, it's going to be a rare circumstance where we can get less than 3 years payback for that initial purchase. And our goal is going to be to get the money back to the family as soon as we possibly can. So there's the timing issue there. The other advantage to utilizing a family loan is the fact that those monthly payments, as I talked about early in the presentation, those do not count as income to the spouse that's receiving them, with the exception of the interest component. Whereas the payments from an annuity, the full amount is going to be counted as income. So that reduces the amount of income that could ultimately be allocated over to the community spouse from the institutionalized spouse. So that's probably why we've had a tendency to use more family loans. But it's, as Keith said, sometimes there are just circumstances where it doesn't make sense to do a family loan. Maybe somebody isn't trustworthy in the family to be able to do it. And that's where it makes a lot of sense to go ahead and use those.
Oh, we never run into families like that, Tim. One of the things, though, many times when that annuity is a non-qualified annuity, meaning that after tax money went to purchase it, and there is a requirement that if you have a non-qualified annuity and you're doing planning with it, that you have to name the state of Indiana as a beneficiary of that annuity to the extent of any medical benefits paid on your behalf. So in a husband and wife situation, if we're going to buy the non-qualified annuity and use it for moms to generate income for her, we would name the state of Indiana as beneficiary for any medical benefits paid to mom. And then hopefully mom lives as long as the annuity does and no money goes to help pay for her care.
Looks like we've got a question coming in, so we will wait to see what that looks like. You know, as that's coming in, Keith, maybe with the PACE program, you want to touch on sort of the geographic footprint of where that's going to be available for clients.
And that's very interesting. When we initially started doing a PACE program in Fort Wayne, one of the first things we had to do was look at where people are aging in the Fort Wayne area by zip code. And where we're at out on Lake Avenue is ground zero, because that's right where the old harvester plant used to be. Mm-hmm. So all those people are aging in their neighborhood. And the idea here is that we have a fixed zip code area that we can serve initially. And so we're anticipating there's going to be 3 or 4 or 5 zip codes in Fort Wayne we'll serve. Eventually, what we'd like to see is a spoke and hub thing, where we actually have a PACE center, whether we just bring people to Fort Wayne or have an actual building in Bluffton, one in Decatur, one in Garrett, mm-hmm. so you could serve the surrounding area. That would be our goal. And the state of Indiana is actually talking about a PACE Without Walls program, where they would provide more integrated care that would be done through more of a capitated payment system so that people could age in place and get services at home. So more on that will come, I'm sure, a little later.
Great. So we got another question. Could you revisit where the proceeds from the sale of the single mother's house went in the first example?
Yeah, so we've made mom ineligible for Medicaid by making the gift for 7 months. And we've got to pay for mom's care for that 7-month period. So son has lent mom $20,000 for the first 4 months to pay for her care. We sell the house in the 5th month, and the $20,000 gets repaid to son. So son now has the original gift amount of $50,000. And we now pay for her care for the rest of that penalty period created by the gift out of the proceeds of the home.
It's important to note, I think, for the person that asked the question, once a Medicaid penalty has started, it does not end. And so the money from the sale of the house can go in to the individual's bank account, can still exceed $2,000, but it still does not change that penalty and how long that penalty period is going to run.
We might have to reapply depending on how much of the proceeds of the sale of the house were
Sure.
at the end of the penalty period. So at the end of the 7 months, we may have to go back and reapply for Medicaid. but it's a lot easier then because they already have all the initial information that was given to them.
Sure. Any other? Oh, you're welcome. Anybody else have any questions? All right, well, we'll let Catherine wrap things up for us today and get you back to lunch.
All right, everyone. Thank you, Keith. Thank you, Tim. We've covered a lot of material, and hey, thank you everyone for your questions. We appreciate them. Thank you for attending our first out of 6 webinar series that we'll be doing. A recording of this webinar will be posted to our website, www.dhblaw.com, and as well as our YouTube channel for your future reference. Next week, our webinar will bring back Keith Huffman and also feature attorney Kristen Steckbeck-Belinsky as they focus the conversation on estate planning and current hot topics, including the Secure Act, beneficiary designations, and a new hot topic, the new advanced directives in Indiana that is coming down the pike. So if you have not already done so and wish to sign up for this webinar, please email events@dhblaw.com or call our office at 260-824-5566. Thank you everyone for attending, and we look forward to seeing you next week. So thank you and have a fantastic day. Thank you, everyone.